Good morning, everyone, and welcome to a new ForoCompetencia breakfast. We have the honor today of having Professor Ioannis Lianos, who is a professor at UCL, but is also a judge at the UK Competition Tribunal of Appeals, and he has been also recently chair of the Greek Antitrust Authority. So he has prepared a paper called Reorienting Competition Law. And without further ado, Ioannis, the floor is yours, and I'll try to see there. All yours.
Thank you. Thank you very much, Francisco and Julian. Sorry, and I appreciate a lot your invitation. I think it's the second time I participate to the ForoCompetencia. Last time I think it was like 10 or 11 years ago, or even more. So it's a great pleasure. And I'll be talking about a recent publication of mine. It was actually published at the Journal of Antitrust Enforcement in 2023. So not that recent anymore, but still, a publication that I think sets a little bit, at least my agenda for competition law and policy. And I titled this presentation, Reorienting Competition Law. And I think that the whole idea started from the understanding that we are living in a liminal moment in the development of competition law, but more broadly, I would say, of the economy. And following the great soul-searching exercise that was imposed to us by the economic phenomenon of digital platforms, the last few years, competition authorities had to weather many storms. I mean, the storm of COVID-19 pandemic, where they had to also, they were confronted to the tidal wave of price hikes and inflationary trends, in particular following the war in Ukraine. And of course, competition authorities around the world have been starting to deal with the sustainable development goals, not only, the environmental and climate change protection agenda, but also the social sustainability one, in particular with regard to the transformation of the precarity of work in the digital gig economy. And finally, the last, I would say, year and a half, more vocally, after the Draghi and the letter and the Draghi report, we have seen calls to enhance the role of industrial policy considerations in competition enforcement, which, if taken forward, may eventually jeopardize the idea that, this is a field of law which is completely autonomous and insular in a way, and that is a field that needs to interact more with other areas of public policy, such as industrial policy as well as trade. And I think this simultaneous eruption of these different policy agendas that last for years, I would say, in combination with the socio-economic developments that have challenged systemic resilience, I mean, like the pandemic or the economic crisis that followed and the inflationary crisis that have been somehow following the war in Ukraine, these may become vectors for significant changes, not only of the methodological and conceptual toolkit of competition law, but also more broadly of the goals and overall role of competition law in the legal and regulatory system of the EU. And let me just say that these are my personal views. I'm sharing them as an academic at UCL. This does not engage any other institution I'm affiliated with, in particular the Competition Appeal Tribunal. So my personal views. So when we are looking to these changes that have happened the last few years, and more generally, when we look to, competition law scholarship, some basically focus on the role of ideology as a major driver for the changes in the field. But I don't think that's entirely correct, because I want to emphasize that is a praxis of competition authorities. And the practical decision-making that they do, I mean, in the context of cases, but also more broadly when they want to adopt guidelines, that is really what, where I can see this type of, change coming in. So it's not really an ideological shift. And I know that there has been quite a lot of discussion in the past about the New Brown Days movement, the Chicago, etc. I think they play some role in somehow developing different arguments that are confronted to the marketplace of ideas. But I think change doesn't really come from ideology. It comes from the fact that, we are dealing with an increasingly more complex environment, and this complexity of the problems requires first an understanding of the complex links between the various phenomena to explore, and secondly, some recourse to complex institutional solutions that eventually may open competition law to interactions with other fields of regulation and other public values than those that have prevailed in the past. So it's not an argument that, reorienting competition law is kind of an ideological necessity. It's more about that, we're faced with very complex issues which are more interlinked than in the past, and therefore that requires from us a different understanding of the problems and different institutional solutions to the problems. And my aim is a little bit to explore that and show a little bit some examples, at least, where the traditional approach that was mostly focusing on price-centric approach, neoclassical price theory approach, has difficulties to provide an adequate and practical reason tool in order to solve these policy problems in a situation of what some people have called polycrisis that we're facing. And that requires that not that we substitute this with something else, but we complement this approach with a more polycentric, complexity-inspired approach to competition law that I think could help us navigate these troubled waters that we are currently facing. So what I would like to first say is a little bit try to introduce this complexity approach, and then identify 2 or 3 areas in which I think having complexity approach will make a difference. So what is a complexity approach? I'll say the essence of the complexity approach is to acknowledge the coordination problems that we face from the fact that individually optimal behavior cannot be defined without knowing about the choices of the other agents in a situation. So if you have actual information asymmetries, feedback loops, path dependencies, and so on, I mean, this is language that is language of complexity science that we have seen being introduced in competition law and economics the last few years, a few decades actually, for concepts like feedback loops and path dependencies. So in the presence of such information asymmetries, feedback loops, and path dependencies, you may face the so-called fallacy of the aggregation problem. So the idea that we have that individually optimal actions that are taken by the agents may result in socially undesirable or Pareto inferior outcomes. So basically that means that we need to place interdependency at the heart of the analysis of systems, which will, including the economic system, which will enable us to integrate in the analysis not just direct interdependencies, but also uncertainty, social rules, social institutions, which need to be taken into account. So, and this is a little bit a different approach than the most simplistic neoclassical price theory approach, which relies on the assumption of perfectly informed agents who can maximize their objective functions in complete isolation, and they're basically only dependent with each other only to the extent that they are dependent on the price vector, right? So basically, under the idea of neoclassical price theory, agents can decide in full autonomy and isolation, and are only indirectly dependent on each other in the sense of being only dependent on the sums of the quantity decisions of all suppliers and demanders in all markets that affects the price, right? So because the price is determined by the supply and demand happening on the market, so you are dependent from that perspective, but otherwise you're totally considered as independent, right? And this assumption is actually quite important because that also is building this idea that you are a rational agent, which is kind of a little bit the same, acting the same, that knowing one individual of a specific category, let's say you are a consumer or you're a producer, is as if you know them all. So you are basically having representative agent models. So agent models where you have consumers and suppliers, and basically all consumers are considered the same. Or I mean, I'm simplifying, but actually that's the basis of this kind of idea of interaction that NPT has on individuals in individual actors in the economy. So in contrast, a complexity perspective will take into account not only indirect, but also direct interdependent relations. So the agents actually, they are located somewhere in relation to each other. So they can be close or distant from each other in a geographic, but also in a functional sense. So, so therefore, the topology, so the basically where you are in the social structure, is particularly important. And the local, in that sense, where you are placed and to which, if you think like the different relations and social and economic relations is like a network graph, where your place is extremely important, because that might determine your survival in the short or in the short term or long term, and the relative success that you might have, because success could be relative in the sense of you're improving your situation, your position with regards to the position of someone else in the social and economic graph, all right, and network. So, so the process of interaction in the complexity perspective is not a one-shot one, but it will be time-dependent and dynamic in the sense that different agents may learn, imitate, or adapt differently. And I think that leads to the conclusion that the optimal rationality, as is postulated by the neoclassical price theory, is impossible to maintain. And agents in this interdependent economy, they have different options to behave, different options to develop a strategy, different conceptions of rationality. They are not really homogeneous, short-run, hyper-rational maximizers, but they are heterogeneous. The relations between these agents are not linear, but non-linear, and they are dynamic. So, and I think that really introduces quite significant complexity in the way you think about problems, right, that you might have and we might solve as a competition authority. So, so what I will do in this presentation, I will say 3 important levels of complexity that I think are relevant for the proper understanding of the challenges that we're facing in competition law, and which might probably show that the MPT paradigm on its own is not sufficient, and we need to somehow add a little bit more complexity perspective. So the first one is the acceleration of the transition of the economy towards financialization and the logic of futurity, which I will explain what it means in a moment, which gives rise to new competitive strategies by undertakings, which are structured as always around the shareholder value principle. Secondly, broader meso and meta and macro level understandings of relationships. And I think that needs also to be taken into account. So the macro perspective and sustainability, I think, and resilience is also, and the emphasis we put recently on that, is basically bringing us the idea that the physical and social environment is something that needs to be taken into account, and that somehow resocializes a little bit competition law. And thirdly, the extraction of economic value through new forms of cooperation, new forms of even labor outside the traditional work environments. And we have the emergence of new ecosystems and value chains, in particular in the intangible economy, where value is created not so much by improving your efficiency as a firm in the sense of reducing your production costs, but actually it might come by enabling an ecosystem of players that are cooperating with you to co-create value, right? So it's not about the development of your own, let's say, scale, but actually to build up an ecosystem of players which are independent from you, but there's actually very close, independent in the sense of they're not vertically integrated, but they are dependent in the sense that they create this local ecosystem which co-creates value together and brings in these dynamic capabilities which are complementary to yours, and that develops value. And I think this is a different way of thinking about value creation and generation in the context of the intangible economy that we need to take into account. So let's start first, and we can move to the next slide. So actually, I will say that was the second slide. So we need to move to the next one. Sorry for that. I should have asked you. Yeah. So in today's financialized economy, I think the most important driver of value creation is not related to present scarcity, but to future expected scarcity that will result from a control of bottlenecks that might become source of expected monopolistic returns in the future. So, and one of the examples that many people cite into that is basically to look to what are the 10 largest corporations by market capitalization. And as you can see from this, the dates actually I think from 2022. This graph is that this picture is that most of them basically are digital platforms that are really orchestrating digital ecosystems, right? So the first four at least, and Meta, which comes after. So and these digital platforms, they have seen their financial markets valuation skyrocket in less than a decade, without, I think, this phenomenal valuation being necessarily justified by current cash flows, at least at the beginning. And in a way, the what motivated, I think, much of this, capitalization is the high expectations that we had for phenomenal profits in the no so immediate future, because of the position that these companies that we call some of them under the DMA as gatekeepers for a reason, they actually have by controlling important bottlenecks in the digital economy. So these bottlenecks can be operating systems, search engines, app stores, the cloud, etc. So and their tremendous valuation actually results from the financial markets imagination of the expected profits, because of the central position that these players have in the networks that power and shape the digital economy, as well as their ability to canalize the activity of their broader ecosystem and users for their own ends. And I think if you move to the next slide, you can see that, I mean, this is taken by a economist, a graph back in 2017 in the column called Schumpeter, where basically you see at the time, 2017, so it's just about we're starting to learn more about the digital platforms, and we had, the commission reports by the British government, the European Commission, of course, the BRICS, etc. So before these were published, there was this idea that, well, look, I mean, these are most of the market capitalization of these companies doesn't necessarily come from the fact that they are, net cash flows that are pretty high. And, Lina Khan has somehow focused on Amazon, and it's called the Amazon paradox, in the sense of, well, they're losing money, but still their market capitalization is increasing geometrically. But it's basically coming from expectations about future profits, not so in the immediate future, but actually not really, let's say, in the next 3 years. That was in 2017, so not until 2020, but also after 2020, so not so immediate profits. And in particular, you see some companies like Amazon and Tesla, etc., where most of the market valuation comes basically from these expected future profits. And I think financialization has basically, I think, an important function to play in the way we think about competition law and policy, because of course this is not something we have been focusing so far, I think, as much as we should. And in a way, if I move to the next slide, I mean, the point can also be made not only with regards to the intangible economy. I don't know if you can move to the next slide, Julian. Julian, can you move to the next slide? Can you hear me? Hello?
I can hear you, but I lost control of the slides.
Okay, sorry. So
Yeah.
and I think when you think about financialization, I mean, it's not only something that affects the digital and the platforms intangible economy, and we have actually a paper last year with Andrew McLean looking a little bit to this angle with regards to competition law and policy concerning digital platforms and financialization, and I think some interesting insights in this paper, but also in the tangible economy, right? So, and particularly, it's very important when you think about commodities and food commodities in particular, and I think what is important, I think, from our side, is to engage a bit more with this price formation process in the financialized economy, and this is fairly complex. It's more complex than the textbook classical price theory one. So of course, physical markets, they bring together buying and selling interest in the physical commodity to level supply and demand imbalances. And this is a classic spot price of a commodity. So the price of a commodity that is readily available to be delivered, and that includes a certain number of risks, commodity risks, transportation risks, price risks. However, I think this is a different game here with the development of future markets, and I think the price formation game is slightly changing. So future markets, they serve as an intertemporal choice of end users by trading expectations on the supply and demand patterns over a time period, right? So firms, they conclude future contracts where two parties agree to buy or sell an agreed quantity of an asset, the commodity, at a certain future date for an ex-ante agreed price. And this matching is done by open platforms, which are usually the standardized multilateral exchange type of platforms, which are highly regulated but not maybe sufficiently regulated, in order to protect the market participants from the high price interest rate risks. So all this is good, and the combined effect of spot markets, forward markets, and future markets enables this international commodities market to emerge. Although I think the size of the financial of a physical depends on the commodity, and the ratio might be sometimes higher than 10%. So, and there has been a lot of question about if this affects if it has impact on the price formation for physical products. And there's been a lot of work there. In particular, I think working sociology, economic sociology on price formation precisely, and actually some of the examples, there have been a couple of books about price formation in cotton markets, where the emphasis was put on the role of market devices, what has been called as prosthetic prices, which are relying not really on this physical interplay, physical markets interplay of supply and demand, but on global indexes that actually have been developed by these intermediaries to help companies set prices in physical markets. And there are sectors of the economy, in particular the fuel sector comes to mind as well, where prices result from an equation in which a price index, usually in Europe, is the Platts or Argus. You can have different types of Platts, so Platts Med High, different types of indexes that be used. And usually, they use basically, this price index in conjunction with some other premium that are imposed, right, by the different refineries to set the price for fuels. So I think the process of price formation needs to be analyzed from this perspective as well, to the extent that eventually the indexes might influence or have impact on the price formation, right? So and you might probably think about strategic behavior in this context. Secondly, I would say over the past decade, there's been a large inflow of investment capital from commodity index traders or index speculators, and these, they seek exposure to commodity prices as part of a broader portfolio strategy. So they treat basically commodity futures as an asset class. It's basically like stocks or bonds. And to a certain extent, this dramatic changes sometimes in market participation have led to a concern that financialization in the form of index speculation may have contributed to, the rise of commodity prices in the last few years. And there's been even an UNCTAD report, I think a year and a half ago, somehow making the point that higher market volatility has led to higher profits for ABCD companies, and high basically profits for the intermediaries in that context. And maybe it has, this financialization may influence also the price levels, right? So some people, there've been a paper by Sokin and Xiong, for instance, 2015. They concluded that the assumption that the futures price of the commodity simply tracks the spot price, that has to be abandoned. This assumption that we had, since the two markets host different groups of market participants, the futures price is not simply a shadow of the spot price or vice versa, but there are dynamics in both markets and there are complex feedback effects that need to be considered. So in a way, I think this is very important to take into account because it introduces like a different dimension in the way we think about price formation, which I think this is not something we have been doing so far, right? In terms of focusing on this dimension in competition and policy. So the second, I think, example I would like to give of this increasing complexity that we need to deal with is sustainability, right? That is an important concern now, at least in Europe. And I think, if you go to the next slide, please. So yes, so despite I think the all the discussions about over the ESG principles, the current calls for competition law to integrate sustainable development concerns introduce, I think, an important level of institutional complexity. So all these initiatives that form part of current efforts to implement the Sustainable Development Goals agenda that was adopted by the General Assembly of the UN. And obviously in Europe, this has taken a very important part of the discussion. And obviously, the current commissioner has expressed herself in favor of the sustainability agenda, and the Green Deal agenda is playing an important role. I mean, obviously, the competition portfolio is one of the areas that she's in charge, and I think this idea of bringing in competition law and policy in a broader context, that of the Green Deal, is something that is very much in the air in Brussels and obviously very much discussed. So I don't know if you remarked some of the recent European Commission's public consultation on the merger guidelines. The Commission and the different texts that they publish. The Commission is not only focusing on price effects; it also actually commissions a report to focus on dynamic effects and innovation. That's going to be a major driver for competition and policy in Europe. Following up a little bit what happened in the UK in 2021 with the merger guidelines then of the CMA, and in 2023 also to a certain extent in the US. So this is an important concern. But actually what is interesting and a little bit different from the US and the UK is that they are also launching in-depth consultations in different fields, including labor markets, resilience, sustainability, security, which somehow are much broader than the classic focus on consumer welfare. And it's interesting to see, how these different reports and these different consultations will fit in. I mean, the law is the same. I mean, the merger regulation is not changing. I mean, it's there. So what is going to change eventually are guidelines. But still, it's quite interesting to look a little bit more to this broader perspective. And what is interesting also, even in the dynamic effects in the commission, in the report that they actually want to commission on dynamic effects, if you look to what they suggest, they are basically saying that we not only want to have the classic macroeconomic industrial organization or innovation theories perspective on things, but we also want to add a macroeconomic perspective, all right? And I think that's quite interesting. And also, we follow a little bit the Draghi report discussions after the Draghi letter report, or the recent discussion in the UK concerning growth. I mean, this is really an important part of the agenda. So I would say this might eventually, make one wonder if this more macro perspective on sustainability, on growth, might enter in conflict with consumer welfare, a concept that has been interpreted as relating to the protection of the interests of the consumers in a specific relevant product and geographic market that is affected by the alleged restriction to competition. And the mainstream interpretation of this concept, we basically only care about the impact of the allegedly restrictive conduct on all direct or indirect users of the product in question. So we need to know at the end that this is going to be at least neutral impact for them, if not favorable. And we know that if you look to the guidelines of Article 1013 and what has been so far also the policy with regards to efficiency gains in merger control, I mean, we require in general the possible harm in the relevant product market to be fully compensated. And in a way, I mean, the Commission guidelines on the application of Article 101, Paragraph 3, which is basically dating now almost 15, 16 years, they state that, I quote, the effects on consumers in one geographic market or product market cannot normally be balanced against and compensated by positive effects for consumers in another unrelated geographic market or product market. Of course, even if they mention that, as I kind of hinted before, I mean, this is a representative agent view of consumer. We're not talking about the same people. So the concept of consumer is not understood as current consumers, customers of the undertaking question, the relevant market, but also subsequent purchasers of that product. But again, by discounting future gains for consumers, the current interpretation of this concept of consumer welfare may not sufficiently account for the interests of future generations. So there has been already a debate occurring on this, particularly I would say also for other network kind of industries to the extent that the airline industry can be considered as a network industry because of the importance of hubs. And that's, one of the things that when we look to the cases concerning airline alliances, they haven't been that strict in terms of, that the benefits to the consumer of the geographic market, which is usually like, point A to point B, they need to be fully compensated. So they have been a bit more open and taking into account the benefits that could, eventually go to the consumers of different geographic markets, right? So there was an openness there, but I think the discussion with the horizontal cooperation guidelines of the Commission concerning Article 101, Paragraph 3 moved a step further, because if you remember, the discussion concerning these horizontal cooperation guidelines was that, there was one view that said that the Commission will take into account the sustainability benefits that come out from the agreements in question, that they have to relate to the consumers of the products covered by those agreements, right? So that is a narrow view. So you'll be only looking to sustainability benefits that come out from the individual use of the product. So they derive from the consumption or the use of the product covered by the agreement under assessment. But then what is interesting is that the guidelines, they added two other forms of benefits that are taken into account. Individual non-use value benefits, so the indirect benefits that may result from the appreciation by the consumers of the impact of their consumption on others, right? So that is something that might be taken into account, even if they are not users of the specific product. And also, thirdly, collective benefits. So where you have consumers that substantially overlap with the consumers of the relevant market affected, that also can benefit from the sustainability that the enhanced sustainability that is enhanced by the specific agreement. So somehow outside the market, sustainability benefits. Now, of course, the question is, what do we mean by substantially overlap? And how much is it a full compensation, not a full compensation? But if you look a little bit to a few months later, after the Commission adopted these horizontal cooperation guidelines, they adopted specific guidelines concerning Article 210A of the CMO regulation, which is basically about the food sector, food supply chains. And there, they said, well, we are more open to sustainability benefits. We don't really necessarily require this full compensation of the consumers of the relevant market. So there is an openness, at least with regards to sustainability in the context of food supply chains. And of course, you have the UK Competition and Markets Authority that for climate change agreements, basically, they did not refer to the consumers or rent market in question that would be affected by the agreement, but basically they looked at the benefit to UK citizens, so more broadly. So in a way, this is an interesting dimension, I think, because thinking about the merger control guidelines, and in particular this new discussions concerning sustainability, resilience, etc. I mean, the way is how you're going to take that into account, right? So you might say that, well, and this is a little bit what the Commission tried to do in the recent market definition notice of 2024. They said, well, it might be that sustainability is a parameter of competition, right? So if sustainability is a parameter of competition, then there's more legitimacy, say, to take that into account in your analysis. Eventually, the same could be said with regards to resilience, although it's a little bit more difficult in this context to make that argument. I mean, in terms of resilience as a parameter of competition, I think eventually resilience is more of a public interest goal, right? And we saw that in the context of the COVID-19 period, where because of the supply chains, the supermarkets were extremely efficient, and they were extremely efficient because they were organized under the just-in-time principle. So there was no room for shocks, and therefore they were not that resilient. Right? And that led, at least in the UK, in the temporary kind of exception to some competition provisions with regards to, in order to maintain basically the resilience of the supply chain. So it's interesting to see, how this is going to be taken into account in the context of a merger. I mean, it's a different thing when you have an agreement, which is basically, you can accept it for a period of time. A different thing when you deal with a merger, basically, which is a more permanent type of market structure change, right? How this is going to be taken into account in this context. Well, labor is something also when we'll discuss in a moment that you might, eventually understand that the importance of competition in labor markets, and there's been quite a recent, emphasis on acqui-hires, or in the context of mergers, or non-poach agreements in the context of cartel investigations. But I think if you take broadly, social sustainability principles as well, I don't think you can easily make the claim that, well, this is a parameter of competition, that's why I'm taking that into account, right? So, and that is, and if that's the case, then, it looks in tension with this emphasis on consumer welfare, in the sense of final consumers or intermediate consumers. And I think I don't have any particular answer to that. It's just somehow showing that the more these values, this polycentric kind of vision you develop for competition and policy, the more complex actually the assessment will be, and different types of sources of wisdom need to be, than just classical price theory, need to be brought forward. And I say the same thing also happens in the discussion with regards to exclusionary conduct. I mean, we have the Meta judgment of the court, which focuses on data protection as a parameter that might be taken into account for building a competition theory of harm. You might also, from that perspective, take a broader view about the constitutional values that eventually might influence some possible theories of harm, right, that you might take. And there's been a lot of emphasis recently on effect on impact of certain practices to democracy, or to affect democratic choice. So the discussion about competition and democracy is booming right now. There have been many contributions from different colleagues. Well, you might also think from that perspective as, democracy-related theories of harm, right? But, what I'm saying about is not just about theories of harm, but it can also be about possible defenses, right, to anti-competitive effects. So all this discussion recently about innovation defense is basically the idea that, well, you have a specific merger that might, result to a price effect. So eventually the prices will go up. But then the idea is, and this is discussed in the Draghi reports, to come in and put forward an innovation defense to the extent that, yes, the price might go up, but this will benefit innovation, and that will eventually come to the consumers in terms of better quality products in the future and more innovative marketplace. And again, that is a kind of a defense, like a innovation serving as a shield, but also innovation might be considered as a sword in some cases. Like you have quite a few cases recently on innovation theories of harm, right? And of course, you have the Dow DuPont cases, you have Illumina Grail. I think we have considered a very interesting case with regards to that. If the case had, if the court had focused on the substance and not on dismissing the and annulling the commission's decision for procedural issues. But I think this is an interesting issue that you take into account. And again, this is more about how you broaden up a little bit your analytical framework when you're focusing on other things than just price and things that are not necessarily related to the use of the specific product by the consumers of the specific relevant market, but also more broadly collective and other non-use benefits that might be taken into account or harms eventually. So that's, I think, a further element of complexity. Now, the third, I think, issue, and if we can move to the next slide, is what I would call as the new economics of value generation and capture in the digital economy. And I think what I mean by that is that first, we have digitalization that engender a profound transformation of the labor relations and consequently of labor markets with the development of new forms of work, but also more generally contribution to the creation of value in the digital economy. So financialization enables a conceptualization of each contributor to the value creation process as it will be small-scale entrepreneur making use of some personal capital, would be the an asset that they have, their time, their specialized knowledge, in the context of a labor platform, which generates rents through the coordination of the effort of other people or maximizing value use through the operation of network effects. And I think these relationships between the different actors are intermediated through these data markets that specifically constituted in order to translate into financial value the various features of human activity involved. And I think part of that is also the fact that digitalization has accelerated the move towards modularization of production and the constitution of business ecosystems in which groups of autonomous firms and individuals take advantage of different sorts of complementary investments and capabilities to create value. So not only value creation is happening, which is happening in the digital economy, takes place across actors in ecosystems, but also this organization value is very much linked to the financialization of the future prospects and the competitive advantage of each ecosystem to capture innovation rents through the operation of financial markets. And that's the first point I made. So I think that's an element that we need to take into account more, right? And that I think justifies also the fact that we are focusing on labor markets as well. So we observe that a great deal of value in the current economy is extracted outside traditional work environments. I mean, we have a traditional work environment. I mean, with an employee and an employer. Well, this is not subject to competition law to the extent that the employee is part of the undertaking, right? So it has an employment relationship. So we're not necessarily focusing on that aspect, but things might change, if, we're moving from wage labor increasingly, as you do in many sectors, and we replace wage labor by other types of labor, such as alternative work arrangements and gig work, as well as by various forms of labor, which is contributed by uncompensated labor, I would say, by users, right? Because, I mean, many of us are also users of platforms and contribute content to these, platforms. And obviously, this is not compensated in terms of, we don't receive any compensation apart from the, free use of the service. And of course, this is definitely something that has been an important evolution in recent years. So, and of course, EU competition law has so far taken a narrow perspective on the concept of consumer, as I mentioned before, or user. The concept is understood as referring to the representative consumer assumption used in classical economics, whose models have more than one class of agents like producers and consumers, and is being representative of its own class and perceived as identical. But I think, that's not something that we can easily do in the more blurred kind of context of value creation nowadays, where, you are a user, but you're also a producer, and you're participating in the value generation process by, providing your car if you are an Uber driver, or your content, if you are, adding stuff on YouTube or on Facebook. And therefore, this is something that I guess will require from us a kind of a more complex understanding of the relationship, and obviously justifies also the fact that we are focusing more now on labor markets, right? And this is becoming quite important, because we have now, we are all basically undertakings now, and we have to a certain extent, if we are contributing to this value generation process, there is an issue also with regards to how you deal with the possibility eventually of Uber drivers or of musicians to collectively bargain as undertakings with other digital platforms. And that really is also what motivated this new economic reality, more complex economic reality, what motivated judgments like the judgment of the Court of Justice in FNV Kunsten, which basically put forward the idea that, someone that could be considered as an undertaking, an independent, still, it's basically a false independent, to the extent that it's dependent on the platform, and therefore you need to provide, in this context, the possibility for these individuals to collectively bargain without, somehow blocking this through the enforcement of competition law. And I think this is definitely an issue that doesn't only, concern competition law, but of course, you have the labor law and specific directive concerning labor platforms that deals with this issue. So moving a little bit the next slides. So in a way, so somehow we have to deal with the concepts that we have, the idea that we're focusing on consumer welfare, yes, but at the same time, we are also bringing in different dimensions. We are thinking of people not just as consumers, but also as citizens, as workers. So, and obviously this requires a more complex set of tools. So one of the tools that have been discussed the last few years is agent-based modeling, which attempts to a certain extent to depart from the abstraction of neoclassical price theory models and brings the role of networks as spaces of interaction to the fore, and I think has important implications on the understanding of power relations within systems. So I think the agent-based modeling is a tool that has been used mostly, I would say, by macroeconomists. In the recent Journal of Economic Perspectives, there has been a quite interesting literature review article by two of the leading contributors to this literature, Doin Farmer and Robert Axtell, basically presenting the tool and looking to the various fields it has been implemented. I think, the benefit of this tool is that it allows for a greater heterogeneity of the agents whose interactions we're modeling. So we can basically develop an ecology of agent types, each relying on different types of behavioral governing mechanisms. And although, these models, these computational models, cannot completely dispense with the constitutional representative agents, it still enables the theorists to construct computational models from the bottom up, with any abstraction be focusing only over the low-level individual entities that make up the system. So in a way, this is something that might enable richer type of models to be developed. And of course, there are issues, and Axtell and Farmer in their paper very much somehow trying to deal with the criticism often put forward for these models that there's an issue of external validity of that. I mean, the fact that there are different multiple equilibria might emerge, which makes things more difficult, etc. But still, I think the function of these models will be very different from the one that we are used to. It's not going to be about getting the answer, or a specific type of somehow very fixed understanding of the situation, but it's going to help us understand the pattern of things and eventually lead to, with the addition of qualitative evidence, of course, to a better understanding of the situation of the phenomenon that we are trying to explore, and the possible outcomes that it might have, if you continue with this pattern, right, of interactions. And that is something that obviously will be less precise, but at the same time, I think more accurate, and will enable us to cope with this increasing complexity that we have to deal with, that we can't necessarily model easily in a micro perspective, right? So, and I think that's something we need to recognize, right? That the more complex the assessment is, maybe the less definite answers or clear answers we're going to have, and that will require a lot of judgment and eventually more discretion for making decisions in this context, to the extent that you have done your homework in terms of methodologically and procedurally, and you have identified the various factors and you take into account for your decision. I think that's good enough, and it's something that obviously will have to be there, but it doesn't mean that we're going to have precise estimations, and we have to cope with that greater unpredictability in that context. And I think this tool might even move even further, I would say, and this is something that I've been working recently with a number of computer scientists. If you introduce AI in these simulations, right? So and use LLMs or agentic AI more generally to develop digital twins or different types of simulations that might help decision maker to assess what could be the situation in case I take this specific approach, or if I take that other approach, which obviously also raises issues with regards to the external validity of that, and what there's been a raging debate now in the field of computational science concerning the if LLMs can be used to make causal arguments, and is it something we can rely upon, etc. I mean, there's a lot of literature that actually, if you're interested, we're going to have. If you are in London, we're going to have a workshop next Thursday, actually, with a number of computer scientists, economists, and data science from competition authorities to discuss precisely this issue. I mean, how can we make causal arguments with LLMs or with digital twins, or with even agent-based modeling, for instance, like of the old style agent-based modeling, not the AI one and Hayes one. But I think definitely that is something that I think, and I've been already, I have in the slide one of the papers that I think probably one of the first papers with the polycentric computational paper back in 2018 that basically, put forward the idea that agent-based modeling can be useful. And of course, many other people actually have followed up this literature, and now there's a little bit more work on that. But I think still, there's a lot of interest and to develop that more, and to calibrate. Probably these models would probably be difficult. You will require probably significant resources, at least at the beginning. But I think this is easier also to collect this data because of digitalization and the expansion of the digital economy. I mean, we are using, and we are living emotions and everything. We are, digital economy is traceable to a level that the analog economy could never be. So that is, sources of information and data that could be used more broadly. It could provide important insights through these different tools. I would say a few words. I mean, if you can pass to the next slide, please, about also the development of what I call meso institutions of the economy. So, like the ecosystems that have emerged over the last decade or so as a new area of study for those interested in competition law and policy. This, I think, concept has been, there's been a huge amount of literature starting from more back in the 1990s concerning ecosystems. That was business literature. And there's been, a huge amount of work on that, different definitions of what is an ecosystem. I mean, you can see in this slide some of the main players in this offering different definitions. But I think that something that probably all will agree is that this is not really about the technical complementarities that might exist because of the development of a platform, of a digital platform and data, right? That, of course, is an important piece of the ecosystem puzzle. But I think these economic complementarities that we're thinking about when we discuss about ecosystem, they're not only resulting from the underlying technical system. And I think Pierre Regibaud, when he was the head of the chief economist of the European Commission, in a speech, I think rightly put emphasis on the importance of organizational rules in developing these complementarities that we take into account in the context of ecosystems. That's not the classic complementarities as we think in the IO context, right? Like, an input is there's a process of production, there's an input and an output and kind of vertical relation. Here is more about value complementarity, right? And Regibaud, I think, rightly puts emphasis on the constitutive role of the rules of the ecosystem as two products, let's call them product A1 and B1, they belong to an ecosystem if both products are subject to rules set by the owner, the orchestrator, as some call, of the ecosystem. And if, because of these rules, it tends to be more attractive to purchase A1 and B1 than to combine any of these with a version of the other, which is not subject to these rules and it's basically coming out from a different ecosystem. So hence, I think the ecosystem requires a mix of ownership and common rules, governance rules, which makes it more likely that consumers will purchase several items from different suppliers, which are basically subject to these the same ecosystem rules. So, and I think, this is quite important to focus on the rules of the engagement, and who does what, the conditions of participation in the ecosystem, who gets what, and the governance rules of the ecosystem. This is really what makes, I think, the value of these ecosystems, or more than just, the technology and the existence of a platform, a technical, basically, platform that is used by the various actors in the digital space, right? So, and I think, focusing on the governance then as becoming the source of the ecosystem value, I think is the right approach. And that also, sometimes when we discuss about, recent cases like the Booking Travelli merger, where, the Commission has been referring to the concept of ecosystem, not necessarily to describe only a situation, right? Because, the concept of ecosystem has been used descriptively to describe, the way, these different digital platforms emerge, and somehow, this is mostly the way that the concept of ecosystem has been used in the reports, all right? Like the Hayek-Schweitzer report and Kremer report, or the Furman report, this is the main way, the Lina Khan report, for the House of Representatives back in the majority report back in 2018-19, if I remember well. That was mostly descriptive, right? But what I'm talking about is using the ecosystem as a operational concept in competition law to assess competition interactions, right? To understand better how, the companies interact. And I think, from that perspective, it's only recently that we've seen this emphasis on ecosystems as an operational concept, and ecosystemic theories of harm some have advanced in mergers like, for instance, the Booking-Travelli merger, with this idea that, these rules of the ecosystem, more than just a technical platform, provides this ecosystem glue that might eventually provide an advantage to the ecosystem by enabling it to steer consumers that are coming to it to other choices that are offered within the specific ecosystem, right? And of course, we have to wait and see what the court would say in this context. And of course, if at all, the Commission guidelines for mergers, as well as more generally also those, I would say, on Article 102 and exclusionary abuses, will refer to this concept or not. I mean, we have, in the market definition notice, a specific section now on digital ecosystems. Although I have to say that this is not really, something very innovative, to the extent that it applies basically an aftermarkets approach to ecosystems. So it doesn't necessarily, develop further the concept as an operational concept. But eventually, this could happen in the European Commission's merger guidelines or the exclusionary abuses guidelines, although for the time being, they don't refer to that at all. So what would be the implications of, I guess, if we open up a little bit, so we go to the next slide, if we, the implication of this discussion for competition law. Let's say we move from a monocentric, price-oriented competition law to one which is polycentric and more inclusive of other broader concerns that are not the concerns that the specific authority, chair, or judge has, but it's basically resulting from the specific legal system. We shouldn't forget that in the EU we have provisions in the treaty, which is called the horizontal integration clauses, which are requesting the Commission to take into account environmental concerns, consumer protection concerns in all their policies, right? So there is a mandate that is in the treaty, which needs to be obviously interpreted by the courts and the competition authorities. So, and these are, when just talking about these specific type of values and concerns, not something that will be opening up to the discretion of decision maker, and I think that there's definitely not any appetite for that. It's more about types of concerns in some legal systems, not in all, which are requested by the legislator or the treaty drafters in our case, with regards to taking into account these horizontally in all policies, these concerns. And the question is, how then you integrate these concerns, right, in the analysis. But I think there's no question that we need to do that. It has to be more inclusive competition law from that perspective. So I think that is something that somehow opens the question to understand if competition can be seen not just as a form of economic tool, but also as a form of social regulation. How specific types of rights that might exist could eventually influence the interpretation of competition law in certain contexts. I gave you before the example of data protection and the right to privacy, Article 7 and 8, data protection, the Charter of Fundamental Rights. Has it played a role in the way the court interpreted Article 102 in the Meta case? I would claim yes. Or the Bundeskartellamt? Certainly yes, because the Bundeskartellamt even referred to constitutional law precedents in Germany concerning the self-determination and digital sovereignty in terms of individual, self-determination in the context of interpretation of competition law, right? So that is something that has already happened. And eventually one could say that could possibly, happen in other contexts as well. Secondly, I think we need to understand better how the value capture and value generation process work in the modern economy. That will require from us to integrate now understanding financialization, the role of futurity, the role of personalization of production, the move from markets to ecosystems, and also, performativity to the extent that if, futures markets and indexes that are being used are shaping the price formation process, well, there might be some performativity there that we need to take into account. That means that we need to be a little bit more open concerning our disciplinary sources. So we need to eventually, and obviously it's very important. So there's definitely no one that I think reasonably puts forward the idea of going back to sterile legal formalism. All right, so no one is in favor of that. But I definitely think that there's a case to be made to open up our sources of wisdom in the sense of looking to significant work that has been done in recent years concerning law and political economy, or economic sociology, complexity science, and eventually other fields that might be of interest for the specific problem that we need to solve. I mean, I always think that if you have a problem to solve as a decision maker, you need to be open, of course, under, you need to have good science presented, right? So, but you need to be open in terms of to the evidence, scientific evidence presented to you that will help you decide better the case, right? So you shouldn't necessarily exclude learning because of, they're not fitting into the specific box of focusing on macroeconomics, right? Or price theory. I mean, you need to be a little bit more open. And I think the recent literature on innovation studies, on dynamic capabilities, etc., I mean, and business studies, I mean, is something that has been very helpful in shaping the discussion concerning innovation concerns in competition. And I think that's I think that's very positive. And therefore, that means that you need to be also a little bit more plural in terms of methodology. So I'm not saying that neoclassical price theory shouldn't be used. I mean, of course, it may be extremely useful, or very useful in some cases, particularly in the tangible economy. But, in more complex settings, where you have in markets where you have different regulatory frameworks, where, in markets where the intangible economy, eventually you need to develop a better understanding of how things work, and that will require you eventually to use also other methodologies and other tools, including agent-based modeling or in silico approaches, as the one I'll be putting forward in some publication that will come out in the summer. So, and that also means that you need to be more open to experimentation, right? So, and I think, this is one of the things that we have been, when I was the head of the Greek competition, we have been thinking a lot about how, we have this issue about sustainability agreements, right? And we don't know what is the right thing to do. I mean, we are experimenting. So let's develop an approach to experimentation. Let's favor that. Let's have a sandbox, right? And this is why we put in place the sustainability sandbox to accompany the effort that was done by the companies and monitor it, but be open, to the extent that we can learn from these different experiences. And I think this is something that eventually this type of regulatory experimentation needs to be taken into account. All right. So and developed with other tools eventually, or not just sandboxes. I mean, we could work with you also think about the tools as well. So I think I'll stop here, and because it's already, I think, spending quite a lot of time. So and happy to take any questions or to any remarks, and I'll be able actually to respond to these. And as I said before, these are my personal views. These are not entirely fixed yet because I'm working on these. I'm researching on these issues. And do not represent at all the views of the tribunal or any other institution I'm affiliated with.
Thank you, Ioannis, for a very complete presentation. I think that you are one of the pioneers of this idea of expanding competition Trust me, today it is not an academic theory. It is what is being discussed everywhere. And many of the things that you pointed out to the in your presentation were now either were discussed today and at the IBA conference and by different jurisdictions throughout Asia and Europe as well. Um, Well, I'll leave the others also to raise their hand if they have questions. I have a first question that you
It's in the chat, isn't it? So I can read that.
it is and the chart. Yes, Jonathan made a question. I don't know if you want to read it loud, Jonathan.
Yes, thanks. No, thank you very much for the presentation. I think it's as Julian is saying is, we hear this concept discussed all the time, and it's nice that you're taking it, a bit further with complexity and with more context. And I thought the first point you made about, how some of these goals may factor into price formation, I thought that was very interesting. My worry with this is is basically why are these new complex goals like sustainability, why should we take them into account in competition law without a legal mandate? Because we've always faced these things, like policy, industrial policy or job creation. There are always discussions of conflicting objectives between competition policy and other socially desirable goals. I can think of the recent debates in European merger control against preventing the emerging of European champions, etc. So why are these goals like sustainability suddenly acceptable and should be taken into account within the discretion that maybe the competition authorities have, and not other goals when they're not strictly part of the legal canon that a competition authority should be looking at when making those discussions, the decisions. And I guess what I'm getting at is, isn't there a risk that you're just picking some objectives that are sort of part of the cultural zeitgeist and excluding others that are not fashionable, but there are no other sort of moral or logical grounds to ignore them? So how do you solve this?
It's a great question. So let me say that, when I wrote these articles, my audience was basically the EU audience, right? So what I'm putting forward is very much related to the fact that, as I mentioned before, in the EU we have in our constitution, I mean, we don't use the term, but I mean it's a treaty. We have specific clauses that actually are putting forward specific objectives, and they actually mandate competition authorities to take that into account, right? So that is in the law. So you interpret the law, and you need to take that into account. And obviously, there's no question, even if you're a positivist and literalist, and you have somehow to take that into account, right? But your question was broader in the sense that, what about jurisdictions where you don't have these mandate, or more generally, you don't have a judge that is someone that is doing only positive law? I mean, someone that is eventually, having to discuss, or judge or competition authority. And also, I have to say that the enforcement system in Europe is very much, so far, a public enforcement system, in the sense that you have the Commission or national competition authorities. Is not really the judges that are, maybe the exception of the UK, where you have more cases coming at the CAT and the CMA, but more generally, I would say in Europe is public enforcement. And it's a little bit different from the US, where there's mostly private enforcement, right? So it's almost mostly a generalist judge that will make a decision, all right? So now, what about the situation where you don't have this type of mandate? Well, there I would say it depends. So if you are someone that is very much inspired by Richard Posner and wealth maximization as a goal in itself, well, obviously, the main goal you're taking into account is wealth maximization, right? And eventually, that will be a total welfare standard, or eventually you will be accepting a consumer welfare standard, not a la Borg, but a consumer welfare standard that is more a distributed justice standard. And why you choose that, why you choose favoring consumers rather than any other stakeholder, is because eventually they're at the end of the process, so they can't pass on anything that comes to them, or because of the fact that there are many and they have different interests, necessarily they cannot be well organized. So you can have different types of theories to justify why you should value more consumers than any other stakeholder, right? Now, that's one possibility. One other possibility is that you are Dworkinian, and you are basically trying to think about what is the best fit and the best interpretation that the Herculean judge, like a perfect judge that will know everything and all the laws and everything, will be able to reach in order to understand better what is the legal system representing, right? And there, if you have to assess the legal system in its totality holistically, and basically find what is the best interpretation, the version that fits the best, right? And that is more of a, not interpretation that fits only the positive law, but also the moral principles that are prevalent in the specific polity, right? So it's not just about the legal framework; it's also about the moral principles, right? And of course, in this context, one will tell you, well, if you are a Dworkinian kind of decision maker, well, that's the kind of thing that you need to do, right? But that's the Herculean, the Hercules, the perfect judge, the superhero type of judge. But still, that's what is the ideal that you should aim at. So, and then if you are a pluralist, you probably be of the view that there's not a single value, even moral or in terms of legal interpretation, that is something that will prevail, but it's you might adopt a pluralist perspective, so you can accept that there's reasonable disagreement between different values and eventually different people, and that obviously will lead to a small diversity in the way actually decisions are made in your legal system. So I can't necessarily give an answer to that, and I don't really want to take a normative perspective in the sense of, wow, this is the right thing to do, because as I said before, well, if you are a economic analysis of law person, or if you are a Dworkinian, or if you are a pluralist, and maybe other possibilities as well, you may reach a different perspective. But I think, in my context, the one that I write, even if you are a boring positive lawyer, you have basically in the law very specific mandates that you cannot ignore. I mean, why it will be complete, I don't know, I think, usurpation of power, if I can use the term, if you do not interpret the law as it is all right? So these are things that you need to take into account. And you cannot necessarily say, well, I'm not taking that into account, right? So, and I think this is something that is a very, very specific answer to the European legal system, but eventually, in other legal systems, the Constitution might mandate sort of things that you need to take into account, right? And therefore, that's something that obviously you need to pay attention to in your interpretation. So what I'm saying is not. People usually say, "Oh, this is really a sort of a discretionary of the judge." Well, no, it's not. I mean, what I'm saying is, in my field, in my area, in my geographic area, the European Union, it's not something that I think one can criticize me, because I'm actually putting forward these views that are in the treaty. I mean, this is the force of the constitutional order of the EU is based on the treaty, right? So we need to take that into account. Now, someone actually I just read that he said, "Oh, is your interpretation rejecting Easterbrook's error cost analysis?" Well, I mean, it's not rejecting it, because I think it could be useful. But what I'm saying is, and I have a very recent paper on that, on the precautionary principle, and I'm saying, well, the error cost framework might work in case you have some scientific certainty about things. So it supposes that you can identify at least what is the outcome, right? only the probabilities of outcomes. So that will enable you to do this error cost analysis. But if you don't have understanding of what it will be the outcomes, you have basically, or even the probability. So you have an unknown, and we have a lot of unknown nowadays. I mean, no one really knows how, what will be the effect of AI. I mean, in 5 or 10 years from now, right? So how can you do a error cost analysis in this context? I mean, when you have, a lot of literature on high impact, low probability events that might happen, and the pandemic and the crisis that actually followed and the war is a high impact, hopefully so far low probability event. I mean, it wasn't low probability like 200 years ago, but this is something that is bringing in a factor that you need to take into account, and that is not easy to do that under the error cost framework. So there, you need to have approaches to deal with uncertainty. And in that context, I would say one argument would be to have a precautionary principle. And this is what I'm putting forward in a recent publication. I think will be out in the next couple of weeks at Theoretical Inquiries in Law, right? Others might have different views. But what I'm saying is I think the error cost framework is interesting, but definitely doesn't deal with these situations of scientific uncertainty and or even a Nazian risk. And therefore there, you need to have recourse to other approaches, like precautionary principle, for instance.
Thanks, Ioannis. Well, indeed, Alan asked another question as well. I don't know if you Alan want to raise it to in the microphone.
Oh, see that. So there is one about David T's. I mean, I really follow David T's work, and I'm a big fan of this next generation competition law article he did many years ago. I mean, he has been writing about capabilities since the 1980s, and I've been following his work. Actually, I wrote a paper like 12 years ago on IP and competition, on dynamic analysis, and I was referring a lot to his work. But I mean, he's not the only one focusing on dynamic capabilities. And of course, the idea here is to understand practically what that will mean in the competition law context, right? How you're going to operationalize this analysis of dynamic capabilities. And also one of the things that I find probably missing in his work, but maybe is because I haven't read all of his work, and is the idea that he thinks, at least as far as I understand, that in the ecosystem, in an ecosystem, digital ecosystem, let's put that. So most of the innovation and dynamic capabilities will come from the orchestrator, like the digital platform. I don't think that is a correct understanding of the situation. I mean, yes, the digital platform and the orchestrator will play an important role, but as I mentioned before, this is not really about the technical aspect, right? It's more about the technical aspect of the platform. It's more about the organizational rules, and this is something that everyone is contributing to. All the stakeholders in the ecosystem are contributing this value, right? And investing in R&D as well, in shaping the rules, in providing knowledge, basically, through their interactions to the orchestrator to develop, basically, through this network type of learning that he gets, the rules to be more effective, right? So I think it's very reductionist to, when you deal with dynamic capabilities, to just focus on the dynamic capabilities of the digital platform or the orchestrator, and not to take a broader picture of the ecosystem and integrate also the dynamic capabilities of the business users, of the complementers, and of the final users, to the extent that the final users, as I said before, they're not just users, they're also contributing to the value creation. So, and I think that is a problem of, at least as far as I understand, of some of David's most recent work, in the sense more reductionist, which probably is coming also from the fact that he is taking a more Schumpeterian, entrepreneur as a hero perspective, which I think is very reductionist in a context where you have cumulative innovation being the rule rather than the exception. I mean, when Schumpeter was writing this stuff, I mean, it was more a world of standalone innovation, but now, it's a world of shared innovation and cumulative innovation. And I'm not entirely sure it's legitimate to say that all innovation, most innovation is coming out of dynamic capabilities of the orchestrator, right? And I think that will be probably where I will differ from his work, which I consider anyway extremely important and interesting, and because he has put in the map, dynamic capabilities for the last 20, 25 years, and I think that's extremely helpful and very important.
Thanks. Paulo has a question. We cannot hear you, Paulo. No.
Hear me now?
No. Now, yes.
Yeah, hello everyone. Hello, Ioannis. Great to see you. Thank you so much for your presentation. It's always very comprehensive, but also deep, and I enjoy very much not on the presentation, but the discussions that we have been having in the recent years. One comment and one question. You in a way you touched on some of these points. But one comment is that hearing you, and I think you make a very compelling argument in the direction of complexity, to use a key word of your thesis of your presentation. It reminds me a discussion that I have seen and heard in Latin America on the constitutionalization of competition law, or alternatively, the disconstitutionalization or unconstitutionalization of competition law. The first pointing to more complexity, so dialogue between competition policy and other public policies, often foreseen in many Latin American constitutions, and the second, less complex and more straightforward. My question is the following. Since this is a Latin American audience, and myself have been very much involved in the region, I'm thinking about developing countries, and in particular, young competition authorities and less developed competition authorities. What should they do? Should they also factor complexity in their day-to-day work, or should they remain in the more straightforward way and wait and see how competition law and policy will evolve around the world? Do you have any reactions on that?
Sure. I mean, it's very interesting the point you made about deconstitutionalization, constitutionalization. One of our former PhD students at UCL, Antonio Leras, as basically his thesis has been also looking to the first emergence of competition provisions and competition statutes or competition-like statutes in Latin America in the 1950s and 60s were basically very much linked to the Constitution. And then since the 1990s, the deconstitutionalization of competition law in Latin America, the fact that, we had to adopt this post-Washington consensus kind of thing, competition policy, and that led to less complexity and eventually more convergence, because the idea was of convergence towards this economic approach, like economic in the sense of microeconomic approach. So yes, and now I think we're facing a kind of reconstitutionalization moment, in the sense that we understand better because of the world that is basically evolving, and the interactions we see, the quite major events that are happening in terms of wars, in terms of climate change, in terms of economic and technological evolution, which is drastic, to basically integrate that complexity. And I think, yes, I mean, this is a moment of reconstitutionalizing competition law. And that's why also, many of the people, at least in Europe, working in the field are very much also constitutional lawyers. Even in the US, I have to say, the New Brandeis movement was actually, they're not so much people that are antitrust experts and that started it. I mean, of course, Lina, etc. But a number of people that have been constitutional law experts, right? And they were bringing in this complexity. Not that the two movements are similar, because my approach, polystatic approach, is not the New Brandeis approach, because of the emphasis I put on social science, etc., rather than legal only perspective on things. Now, what about the developing countries and smaller authorities? Well, I mean, it depends on the political economy of each jurisdiction, right? So, I mean, I was actually the head of a small authority, but still that authority, for a period of 4.5 years, put in the agenda, not only in Greece, but also more broadly in Europe, sustainability, not just environmental sustainability, but also social sustainability, because I've been extremely also present in the discussions with regards to the recommendation of the Commission concerning collective bargaining. But also, we develop innovations like the sandbox. We put in place the first in Europe, and I think the only so far, of a provision concerning invitation to collude and price signaling. We actually had the first cases, not only in Europe, I say in the world, which relate to in the application, not in merger control, where it was first discussed at the European Commission level, but in market investigation, reference of common ownership, theories of harm. So it is possible, even if you have a small authority or even an authority with in a developing jurisdiction, the possibility to innovate and the possibility to experiment. And I think, however, you need to be very careful in regard to the resources that you have. All right. So I think the priority is always to ensure that you enforce the law in an effective way so as to bring benefits to the consumers and the businesses and the citizens. And of course, organizing work or developing new topics which are fitting the specificity of the problem. So the common ownership literature, we actually brought it in because we had the first case where we had a family fund that was basically getting minority shareholding of the two most important construction companies in Greece. All right. So, and that raised a number of issues. And so it was a natural somehow element that we needed to tackle, because otherwise we won't be able to deal with the problem. All right. So I think this is a kind of approach that you shouldn't necessarily say, well, that's not for me, it's too complex. And of course, there's a global academic market, if I can use that term, for expertise. We, as many competition authorities, we have been using experts that are sometimes, because when they do work for competition authorities, academic experts in particular, they're willing to help. And I think this is something that a number of competition authorities may use, and that will facilitate their work, and certainly something that even smaller authorities and authorities in developing countries can also do. And then, I think the final thing I want to say is that there's also some benefit in cooperation. So you might pull resources together with other authorities to develop learning about a specific issue that is of interest. For instance, concerning sustainability, environmental sustainability, we pull resources together with the Dutch competition authority, who is a much bigger authority with more experience than the Greek authority in these matters, to commission a report and to work on a report on sustainability benefits in competition assessments, which I think was published back in 2022. I think, to my knowledge, the only report available so far dealing extensively with how sustainability benefits may be integrated as from an economic perspective to competition assessment. And this report was drafted by two environmental economists and one industrial organization economist. Right, so there are possibilities even for a smaller authority to be innovative and to develop in cooperation eventually also with other authorities.
Great, thanks, Ioannis. Final concluding remarks?
I don't have any conclusion, but I think it's work in progress in the sense that things are evolving at the same time as we're speaking and discussing about the topic. New issues come up. The industrial policy element is not completely new. It has been there discussed in Europe since actually the beginning of the merger control. One of the first merger cases in Europe in 1991, Alenia, Haviland was basically about also industrial policy at the time. But so there, these topics come up again, and I think the important thing I will say is to be open to develop discussions about these topics, and for competition authorities to do R&D work that is essential in order to be able to tackle the complexities of the current situation, and the geopolitical environment that is changing.
Great. Thank you very, very much, Ioannis, for your generosity both in time and in knowledge. So we appreciate it. So we conclude today's event. The next event will be on July 12th. We're going to analyze merger control Latin America in times of change, and we'll have three speakers. It will be Lucia Ojeda from Mexico, Marcelo Caleri from Brazil, and Felipe Serrano from Colombia. I look forward to seeing you all then. Thanks very much, Ioannis. See you soon.
Thank you very much for the invitation. Again, pleasure.
Yes.
Thank you.
Bye-bye.
Thanks. Bye.
Thank you.